Good morning, everyone. How are you? Can you hear me just fine? That's great. Well, thanks for the introduction, Kyle. Like you said, my name's Patrick Carr. I'm a tax associate here in Richmond. I'm a second year. And, I assist, businesses, individuals, everyone alike with their tax problems. I mostly just do what Conrad tells me, though. So today, I'm going to be keeping with the theme of talking about partnerships right before Valentine's Day, but I promise this is the only advice I'll give you on partnerships. And we're just going to be talking about some newly issued final regulations on the allocation of partnership recourse liabilities. Very interesting. So today, we're going to break it down into a couple of sections. We'll just do a brief introduction on when it was introduced. We will look at an overview of the PowerPoint and some essential terms for understanding basically the entire presentation. And then we're going to look at three major changes. One for overlapping economic risk of loss. Two is a change for tiered partnerships. And three is changes to the related party rules. And then finally, we'll look at the effective date. And some of these are modifications, some are changes, some are just codifying things from the temporary regulations, which were proposed a long time ago. So first and foremost, in December of 2013, the IRS issued proposed regulations on the allocation of partnership recourse liabilities. So this was over a decade ago. And interestingly enough, the IRS in their preamble says, well, things really haven't changed that much for this, so we're not going to repropose these. You guys will, just deal with what we put out. So it's kind of interesting because then in November 29th, they issued final regulations, kind of to everyone's surprise, because it took so long, they didn't repropose anything, and they just basically took comments from previous years. And the final regulations provide guidance on a multitude of issues, and they clarify some pain points from the 2013 temporary regulations. And those primarily relate to overlapping economic risk of loss, the treatment of recourse liabilities in tiered partnership structures, and the application of related party rules for the allocation of recourse liabilities. So just some quick background. Section 752 is really the bread and butter when you're talking about recourse liabilities. And it basically permits partners of a partnership to include their share of partnership liabilities in their tax basis if it's a recourse liability. And this is obviously important because whether or not a partner will recognize gain on distributions or they're allowed to claim losses for deductions for losses. So the corresponding Treasury regulations of 1.752-1 through 3 give us two different types of liabilities. And these are probably as simple as definitions as you'll get with any tax code. Basically, you have liabilities that a partner bears the economic risk of loss. Those are recourse liabilities. And then pretty much anything else is what they say is a non-recourse liability. So what is the key term of economic risk of loss? And it's basically when you have a partner that's guaranteeing the liability in some sort of way, whether they would have a payment obligation under a constructive liquidation, whether they're a lender to the partnership, whether they're guaranteeing payment of the interest on a partnership liability or pledging property as a security. So in all these circumstances, a partner will be deemed to have the economic risk of loss of that liability. It will be a recourse liability and it would be included in their tax basis. So the first change we're going to look at is situations where there's overlapping economic risk of loss. And this is more so just a slight modification and just codifying the proportionality rule. So in 2013, the temporary regulations realized that there are certain situations and circumstances where there is an overlapping economic risk of loss, and it kind of creates an inconsistent recourse liability for these partnerships when imputing their tax basis. So it resolves ambiguities with that by having this proportionality rule as a formula. And that formula is pretty simple. It's just going to be your total recourse liability, and then it's multiplied by the fraction, which is the partner's individual economic risk of loss over the total economic risk of loss. And that kind of creates your recourse liability for each corresponding partner. So we have an example here. So it's partners A and B, and they make up partnership AB. Partnership AB borrows $1,000 from the bank. A guarantees the liability entirely, and B pledges $500 for anything that if the liability is not covered. So because of that, you might say, wow, look at that. I mean, maybe you didn't say that, but there's a $1,500 economic risk of loss here because we have one partner pledging $500 and one partner pledging $1,000. That seems inconsistent because we only had an initial $1,000 liability. And the proportionality rule would solve that by taking, for partner A, for example, you would take the initial liability of $1,000. And then you would take partner A's share, that $1,000, over that total recourse liability of total economic risk of loss of $1,500, and you'd get $667. And that would be the amount of the liability that is allocated to partner A. And unsurprisingly, the other part of that would be for partner B, you'd have the $1,000 multiplied by partner B's share, and that gets you $333. And that proportionality rule just creates a more consistent result. So that way we don't have an excess of economic risk of loss for the initial liability. So it's kind of just clarifying some past ambiguities. So the second issue relates to tiered partnerships. And there was, again, some ambiguities associated with when we have a sort of partnership structure where there's a lower tier partnership and an upper tier partnership. And an owner in the upper tier partnership is also present in the lower tier partnership and bore the economic risk of loss for the liability of the lower tier partnership. So the regulations now provide a two-step process to allocate liabilities in this situation. So first, the partnership determines which partners of both the lower tier partnership and the upper tier partnership bear the economic risk of loss for the liability. Then the partnership allocates the upper tier partnership sum of the economic risk of loss to the liabilities for which the upper tier partnership bears the economic risk of loss and the liabilities for which each partner of the upper tier partnership bears the economic risk of loss, excluding if a partner is present in the upper tier partnership and the lower tier partnership. And I know that's a lot to process, so I have an example here. So simple enough, you have partner A and partner B are equal partners in partnership X, which is the upper tier partnership here. And then partner A and partnership X are equal partners in partnership Y, which is the lower tier partnership. A and B personally guarantee the loan, and X takes out, the lower tier partnership Y incurs a liability of $2,000 that both A and B personally guarantee. So first and foremost, we're going to divide the liability. So A and B would be allocated 50% of the lower tier partnership's liability. But interestingly enough, because A is a direct partner in the lower tier partnership, the final regs are going to say, okay, you're already in the lower tier partnership, which has this loan. So we're going to directly allocate the liability to you in this lower tier partnership to A. The remainder of it is going to get passed to the upper tier partnership, that remaining 50% of the recourse liability. Then the final regulations tell us we're allocating it to this upper tier partnership, but because A already received their share of the recourse liability, they're not going to get it again. So we're going to give the remainder to B because B is the partner in the upper tier partnership, and we exclude partners that are in both the upper tier and lower tier partnership. So B would get the other economic risk of loss and the corresponding recourse liability. So next, there are some modifications, really 4 modifications in respect to the related party rules under Code Section 267 and Code Section 707 for determining who is related to a partner who bears the economic risk of loss and how we allocate these recourse liabilities. So the first modification is disregarding the constructive ownership rules under Code Section 267C1, which treats partners and shareholders as owning proportionate shares to their partnership interests owned by a partnership or corporation whenever a corporation bears the economic risk of loss for a partnership liability or a lower tier partnership bears the economic risk of loss of a liability of an upper tier partnership. So an easy example of this would be assuming that individual A is a limited partner in partnership X. Corporation C is the general partner of partnership X. We're on the right slide. So A owns all the outstanding stock of the general partner C, and partnership X has a $2,000 liability. So although the final regulations with this modification effectively say that C as the general partner bears the economic risk of loss of the $2,000 liability, and although A wholly owns C, it's not treated as related to C. Instead, C is allocated all of X's $2,000 liability, not A. So the second modification relates to controlled groups, and it's basically another disregarded rule in that the partnership attribution rules of Code Section 1563E2 do not apply when determining when two corporations are treated as related because they're members of a controlled group. And I think a lot of the reasoning behind these related party rules is we really just don't want to, unintentionally dish out recourse liabilities to people who aren't, really bearing those liabilities simply because they're a related party. It seems like a lot of the time these related party rules are to capture people, but here we're really just trying to separate them and saying, no, actually, you're not going to be allocated any recourse liability in this partnership. Sorry. So change 3 is one of the more interesting ones to me. And it basically provides that when a person owns an interest in a partnership directly or indirectly through one or more partnerships and directly bears the economic risk of loss for the partnership liability, then other persons owning interest in the partnership will not be treated as related to the person who bears the direct economic risk of loss. And that's really illustrated in this example. So we have lender L makes a $2,000 loan to partnership X. Partners A and B, who make up part of partnership X, are related to lender L. A holds a 10% interest in X's profits, so a 10% interest in the partnership profits. B holds a 30% interest in X's profits. So A and B, because they're related to lender L, are treated as having the economic risk of loss for the $2,000 liability because they are related to L. And because we have this A and B have 40% of the partnership profits, we take that 40% and that basically becomes our whole pie of how we're distributing this recourse liability, interestingly enough. So because A has a 10% interest of this aggregate 40 now, they would have a 25% interest in the recourse liability. Well, B has 30 over 40 or 3/4 of the interest in the recourse liability. Therefore, A will bear $500 of the recourse liability, while B will bear the other $1,500 for the recourse liability. And as you can see, interestingly enough, the other 60% of that partnership where those partnership profits are being distributed aren't going to bear any economic risk of loss or have that recourse liability because they're not related to lender L. So it kind of creates an interesting result with sort of allocating the economic risk of loss and the recourse liabilities. So finally, we're looking at modification 4. So modification 4 is where a person other than a partner directly bears the economic risk of loss of a partnership liability, and that partner is related to more than one partner. The partners will be considered related to the person bearing the economic risk of loss of the liability and will be allocated the corresponding liability in proportion to their interest in the partnership profits. So an example here would be corporations X, Y, and Z are all equal partners in partnership X, Y, and Z. A, an individual, wholly owns X and Y. Z is an unrelated party in this circumstance. So XYZ as a partnership borrows $1,000 from the bank. Both A and Z both guarantee the entire amount of the liability. So we have A, who's wholly owning X and Y. A would directly bear the economic risk of loss from the bank and is related to more than one partner, X and Y. So X and Y will actually be allocated the corresponding recourse liability. So X and Y would have the $500 of the economic risk of loss. Applying the proportionality rule, X and Y are allocated a quarter of the liability, and Z, as the unrelated party, still gets his half of the pie. So that is another interesting result with the related party rules, is we kind of look through to see who A is owning in this circumstance, and that's how we're distributing it instead. So probably the most important part, and this is kind of interesting with the effective date here. Like I said, I think a big reason of why this wasn't reproposed is sort of the more reasonable, lax effective date and how it works. So basically the final regulations apply to any liability incurred or assumed by a partnership on or after December 2nd, 2024. However, liabilities incurred prior to the effective date, although not subject to the final regulations, the IRS says, or the Treasury Department says, a partnership may elect to take past liabilities that are outstanding and apply these rules as long as they do it consistently. And another interesting part is that if a partnership liability is in existence before the effective date and it's modified or refinanced after the effective date, then the new regulations, the new final regulations, don't apply to the portion of the refinanced liability that was in existence before the effective date. but it will apply to the portion of the financed or modified liabilities that happen after the effective date. So you can kind of have inconsistent treatment there with that refinance liability if you're not careful. So it's definitely something to really evaluate when you have those particular liabilities. And that is everything I have to say. And, I hope you enjoyed it. If you could enjoy allocation of recourse liabilities to the best you could. Thanks for coming out today.